The Noise Abatement Act 1997, 26th of March. Section 1. This act may be cited as the Noise Abatement Act. That's a short title. Section 2. Interpretation. In this act, political meeting means any assembly or gathering of persons, A, convened by a member of parliament, or 2, a member of a parish council or a councillor of the Kingston and St. Andrew Corporation, or a political party or any member of a political party for the purpose of the transaction of matters of public interest, or for the discussion of such matters, or for the purpose of the expression of views upon such matters, or B, convened for the purpose of furthering or criticizing the aims, objects, action, or program of any political party, or for the purpose of supporting or opposing the candidature of any individual as against any other or others at an election for a member of parliament or a member of a parish council or a councillor of the Kingston and St. Andrew Corporation. And if any speaker at any assembly or gathering held as aforesaid refers to or discusses the aims, objects, action, or program of any political party or the candidature of any individual at such election, such assembly or gathering shall, until the contrary be proved, to be deemed a political meeting. Alright, so that's a political meeting. Public meeting includes any meeting in a public place and any meeting which the public or any section thereof are permitted to attend, whether on payment or otherwise. Specified equipment means any instrument or device mentioned in paragraph A or B of subsection 1 of section 3. Section 3. Noise from private premises and public places. Subsection 1. Subject to subsection 2 and section 5, no person shall, on any private premises or in any public place at any time of day or night, A, sing or sound or play upon any musical or noisy instrument, or B, operate or permit or cause to be operated any loudspeaker, microphone, or any other device for the amplification of sound in such a manner that the sound is audible beyond a distance of 100 meters from the source of such sound and is reasonably capable of causing annoyance to persons in the vicinity, so, however, that were during the period specified in subsection 4, such sound is audible beyond that distance in the vicinity of any dwelling house, hospital, nursing home, infirmary, hotel, or guest house. Such sound shall be presumed to cause annoyance to persons in that vicinity. So whether somebody complain or not, under the law, it is presumed that such sound causes annoyance to persons. All right. Subsection 2. No person shall operate a loudspeaker A. later than 11 o'clock in the night at a public meeting, and B. later than midnight at a political meeting held between nomination day and the day next, but one before election day, both days inclusive. 3. Any person who contravenes the provisions of the subsection 1 or 2 shall be guilty of violating the public peace and shall be liable to summary conviction in a resident magistrate court. In the case of a first offense, to a fine not exceeding $15,000, or in default of payment, to imprisonment not for a term not exceeding 3 months, or B. in the case of a second offense, to a fine not exceeding $30,000, or in default of payment, to imprisonment for a period not exceeding 6 months, or C. in the case of a subsequent offense, to a fine not exceeding $50,000, or in default of payment, to imprisonment for a term not exceeding 12 months. And in addition, the court may, upon the application of the prosecution, order the forfeiture of the specified equipment used in the commission of the offense. 4. The period referred to in subsection 1 are A. 2 o'clock and 6 o'clock in the morning on a Saturday or Sunday, and B. midnight on a Saturday, Monday, Tuesday, Wednesday, or Thursday, and 6 o'clock in the following morning. So, no loud noise between midnight and 6 o'clock on Sunday, Monday, Tuesday, Wednesday, or Thursday, or between 2 o'clock and 6 o'clock on Sundays, Saturday or Sundays. But this also has Sunday in it. Midnight to 6 o'clock anyway. Section 4. Liability of owner of premises to the or equipment, etc. Subsection 1. The occupier of any premises on which an offense under Section 3(1) has been committed commits an offense if the court is satisfied that A. he was present on the premises at the time of the offense, and B. he had not taken all reasonable steps to prevent the commission of the offense. Subsection 2. An owner or operator of any specified equipment used in the commission of an offense under Section 3 commits an offense if the court is satisfied that A. he was present at the place where the contravention took place, and B. he had not taken all reasonable steps to prevent the commission of the offense. Subsection 3. Where the prosecution proposes to apply for forfeiture of any specified equipment under Section 3(3)(c), notice of such intention and of the grounds therefore shall be given forthwith to any person who, to the knowledge of the prosecution, is the owner thereof. So the owner of the equipment must be notified. Notified that the equipment will be seized. Subsection 4. Without prejudice to any other form of service, notification may, for the purpose of subsection 3, be made by 2 publications in a daily newspaper printed and circulated in Jamaica, the second of such publication being not later than 3 days after the first. 5. Any person having a claim to any specified equipment in respect of which an application for forfeiture is made pursuant to section 3(c) may appear before the court on the hearing of the application and show cause why an order of forfeiture should not be made. Oh, so it seems to be saying that here, if you see a notice that the equipment is going to be forfeited and it is your equipment and you are not involved in this, then you can go to the court and say so, and therefore that would maybe justify why the equipment must not be seized, be forfeited. Anyway, subsection 6, where on the hearing of an application pursuant to section 3(c) for forfeiture of any specified equipment, no person appears before the court to show cause why an order for forfeiture should not be made, the court shall presume that such equipment has been abandoned. 7. If upon the application of any person aggrieved by an order made by the court under section 3(c), the court is satisfied that it is just to revoke such order, the court may revoke that order upon such terms and conditions as it deems appropriate, and without prejudice to the generality of the foregoing, shall require the person to pay in respect of storage, maintenance, administrative expenses, security, and insurance of the specified equipment such charges as shall be approved by the court, not exceeding 1.5 times the value of the equipment, as determined by the court as a precondition for the release of the equipment. Okay, so you may have to pay money for them to release your seized equipment. 8. Subsection 8. An application to the court under subsection 7 for the revocation of an order shall be made within 30 days of the date of the order or within such greater time not exceeding 3 months after the date of the order as the court may allow. Okay, so you have to apply asking the court to release your equipment within 30 days or up to 3 months depending on the circumstances. Anyway, section 5, permission requested for operation of specified equipment in certain cases. Subsection 1. Where a person intends to operate any specified equipment to provide music for dancing or other form of entertainment in a public place in circumstances where such music is reasonably capable of disturbing any person occupying or residing in any private premises, such person shall make a written application to the superintendent of police in charge of the division in which the activity will be held for permission to do so, not later than 10 clear days before the date on which it is proposed to hold such activity. So if you're going to be having a session keep a dance, concert, whatever it is, where there's loud music, you must apply to the superintendent of police in that division within 10 days. It must be submitted less 10 days or less. It says 10 days. Let me see if I can find that again. Shall make a written application to the superintendent of police not later than 10 clear days, right? 10 days or less before the date that the dance will be held. All right. Subsection 2, every application under subsection 1 shall contain particulars of the nature and purpose of the proposed activity, the place at which, and the hours during which it will be held. Well, I guess the same would apply to our church meetings and crusades as well. Right? You have to apply for permission. Here, where any specified equipment is used to provide music for dancing or any other form of entertainment in the vicinity of any hotel, dwelling house, or guest house, such activity shall not continue later than 2 o'clock in the morning. 4. Subsection 4. The superintendent of police may, upon request of an application under subsection 1, refuse to grant permission or may grant such permission subject to such conditions as he may specify in writing. So, however, that no permission shall be granted for the operation of specified equipment in the vicinity of any hospital, nursing home, or infirmary. So, no permission will be given where the location of that entertainment event is within the vicinity of a hospital, nursing home, or infirmary. Subsection 5. A person aggrieved by A decision of the superintendent of police refusing to grant permission, or B, any condition subject to which permission is granted, may, within 7 days after the date of that decision, appeal in writing to the Commissioner of Police, who may revoke, vary, or confirm such decision subject to such condition as he deems necessary. Subsection 6. A person who contravenes this section or fails to comply with any condition relating to the grant of permission under this section imposed by the superintendent or by the Commissioner of Police shall be guilty of an offense and shall be liable to summary conviction in a resident magistrate court to a fine not exceeding $100,000 or in default of payment to imprisonment for a term not exceeding 6 months. So if you keep dance without permission, you can be fined up to $100,000 or imprisoned for up to 6 months. 6. Power to seize and detain specified equipment. Subsection 1. Where A person hereinafter referred to in the subsection as the operator is playing upon any musical instrument or operating any specified equipment in the vicinity of any dwelling house, hospital, nursing home, infirmary, hotel, or guest house before the hours of 10 o'clock in the evening and 6 o'clock in the following morning in such a manner so as to be reasonably capable of annoyance to persons in that vicinity. B, where the operator is requested to reduce or discontinue the sound caused by the specified equipment by or on behalf of any such person who is affected by the sound, and C, the operator fails to comply with that request, the operator shall, without prejudice to subsection 2, be guilty of an offense against this section and shall be liable on summary conviction in a resident magistrate court to a fine not exceeding $20,000 or, in default of payment, to imprisonment for a term not exceeding 6 months. So the police tells you to turn it off or turn it down and you don't do it, you can be imprisoned for up to 6 months or fined $20,000. Subsection 2. Where a request is made as mentioned in paragraph B of subsection 1, because of serious illness of any person or for any other reasonable cause, and the request is not complied with, a member of the constabulary force not below the rank of sergeant may seize and detain any specified equipment used in the commission of the offense. So, however, that such seizure and detention shall, subject to the provision of section 3, be for such period only as may be necessary for the purpose of any investigation, trial, or inquiry. Section 7. Regulations. The minister may make regulations generally for giving effect to the provisions and purposes of this act.